Assalamualaikum warahmatullahi wabarakatuh. This is part 3 for the lecture. The topic is damages. So in part 1, we have covered the cases, okay, and the case law, the common law cases, and also the rule on from section 74, subsection 1, Contracts Act. And then for part 2 of the lecture, we cover the first limb, okay, and then now part 3 of the lecture, we are going to cover the second limb of section 74, subsection 1, Contracts Act 1950. So second limb, it emphasizes on the elements of knowledge. Okay, the relevant part of the provision is from the word or, okay, or which the parties knew when they made the contract to be likely to result from the breach of it. So here from this particular provision, it requires the contract breaker to know, okay, or they knew, he knew, it happens in the past, he knew at the date of the contract the special circumstances of the other party, the victim. Hence, unable, okay, the contract breaker is unable to foresee that whatever breach on his part, okay, it will cause more loss, okay, it will cause loss to the other party. So for this second limb here, we have illustration at least I, J, L, and M. So I don't have time to read it all. So maybe I'll try to read one of from the 4 illustration here. I, J, L, and M. Okay, I'll read to you M. A sells certain merchandise to B, warranting it to be of a particular quality. So he give the warrant, okay, the assurance here. And B, in reliance upon this warranty, sells it to C, okay, with similar warranty. So the goods prove to be not according to the warranty. So it doesn't reach the expectation or the character or the features here, the specification. And B becomes liable to pay C a sum of money by way of compensation. So because of that, B is entitled to be reimbursed this sum by A. So who breached the contract? Okay, who broke the contract in this case? A. So B is supposed to pay C, but B can claim from A, the one who breached the contract. Because why? A knows, okay, the requirement, okay, the warranty that he has given to B, and then B gave it to C, the warranty. So you can read further on your own illustration I, J, and L to illustrate the application of second limb of section 74, subsection 1. We go to the case law now. The case is Tam Xiaotou and Associated Metal Smelters Limited, 1972. This is an appeal case. So the appellant sold, this is a sale and purchase case, sold to the respondent a melting furnace. Okay, I have a picture of furnace after this. Okay, a melting furnace as per respondent specification. And the specification is that, okay, the furnace was supposed to reach temperature of 2600 Fahrenheit. But when the furnace was delivered, okay, it didn't reach this temperature. So because of that, the respondent, the purchaser, wanted to return the furnace to the appellant. Respondent, because they cannot use the furnace that they have ordered, so they ordered another two new furnaces from Australia to replace the one supplied by the appellant. So now the respondent sued the appellant for damages suffered by them as a result of the furnace never reaching the temperature required. The temperature was 2600 Fahrenheit. For lead smelting, okay, for which it was purchased. So cannot function, cannot serve the purpose that it was being purchased. This is the picture of melting furnace, okay. I mean, it has to reach certain very, very high temperature. Okay, and then when the case was brought to the court, so this is the judgment. Basically, the court have examined all the relevant facts here, okay, and the conclusion was that the measure of damage recoverable involved the consideration of section 74. And then this section 74 has substantially affirmed the rule of common law case laid down in Hadley and Bazendale. And then the court reiterate there are 2 parts, even though in section 74 it doesn't really say clearly part 1, part 2, but here in this case the court break it into 2 clearly. Okay, first one, damage arising naturally, and we have covered it in our previous part of discussion. And then now the second part, okay, here when they are when they are such as may reasonably be supposed to have been in the contemplation of both parties at the time they made the contract as the probable result of the breach of it. So it's in their contemplation. They know if the furnace doesn't reach this specific temperature, so it won't serve the purpose in which it was bought, okay, by the respondent. So in the court's view, this case fall within the second rule or second limb or second part or second branch, okay, second head, whichever words that you can use, all synonymous or more or less similar, okay. So which is that the appellant would not be liable for payment of damages for loss of profit, okay, unless there is evidence before the court that the special object of the furnace had been drawn to their attention. Yes, it was in affirmative, okay. And that they contracted on the basis that the delay in delivery of the particular furnace would make them liable to payment of loss of profit. And then after scrutinizing, okay, after examining, okay, after going through all the facts here, it will appear from the evidence that the appellant knew, element of knowledge was satisfied, knew that they were required, okay, to deliver a furnace which could produce a temperature of 2,600 Fahrenheit. So it's in their contemplation when they entered into the contract of sale and purchase of the furnace here. Okay, so by their promise to deliver the furnace within 45 days, which is quite a specific duration here, okay, after confirmation of the order, they must be assumed, remember the imputed knowledge, okay, they must be assumed to have appreciated the urgency of the matter. So it's very urgent, they need it, okay, for their business. So in this way, the court said it is reasonable to think that any delay in the delivery of the required furnace will affect the business or profit of the respondent. What more if the delivered furnace was not, it doesn't fulfill the specific specification. Okay, that's the first case for second limb. Okay, we also have another case. You can read the facts in the textbook here. Okay, but we just zoom to the relevant part here. Winston Malaysia dan Berhad, Lembaga LPPKN, Lembaga Penduduk dan Pembangunan Keluarga Negara. So in this case, okay, the observation by the court was that the losses of the plaintiff flowing from the breach, okay, by the defendant were well within the reasonable contemplation, okay, of the defendant at the time the contract was breached. So defendant knew, okay, when it happened, they knew, okay, whatever they are at here, it will cause the losses to the other party, okay, to the plaintiff basically. Okay, the subtopic that we want to discuss now is also relevant to second limb just now, okay, the concept of remoteness of damage, which is damage was not too remote, because if the damage was too remote, then it's not claimable, okay, the claim won't be allowed by the court. So not every type of damage caused to the plaintiff as a result of the breach of contract will be recoverable. So if the loss flowing from the breach of contract is too remote, okay, then it cannot be recovered. It has to be proved not to be too remote. So losses to be recoverable must have been within the reasonable contemplation of the parties, because if it's not within reasonable contemplation, then it is considered as being too remote, meaning that here the sequence is broken, okay, the connection or the I can't remember that, but I think it's quite similar to the concept of a law of thoughts, okay. But for law of thought, they have the word like chain of causation, but here it's about the linkage, okay, between whether it's too remote or not, the damage suffered by the plaintiff. Okay, for remoteness of damage, we have illustration K, P, and Q, right, from section 74. Let me have a look. Which one I want to read here? K, P, and Q. Okay, K is long. You can read on your own. K, L, and M, or P. Okay, let me read to you P. P is the shorter one, actually, to save time, okay, for the recording here. So P, A contracts to sell and deliver 500 bales of cotton to B, okay, on a fixed day. A knows nothing of this mode of conducting his business. So elements of knowledge was missing here. A breaks his promise, and B, having no cotton, is obliged to close his mill. Okay? A is not responsible to B for the loss caused to B, okay, by the closing of the mill. So more or less it's similar to Hadley-Bazendale, isn't it? Okay. So in that particular, I mean, in the illustration that I have read just now, so contract breaker has no knowledge, okay, of the special circumstances of the other party. So that's why it is considered as the damage is too remote. Yeah, damage is too remote, so it's not claimable. Okay, and we are still discussing second limb actually. Okay, the concept is relevant for second limb. If you read illustration K, that's basically the analysis here. Okay, the illustration K, the contract breaker did not know the special circumstances, okay, of the injured party, that the purpose he purchased a certain machinery, okay, from the contract breaker was to perform a contract that he made with the third party. So whatever special knowledge must be revealed, okay, must be informed, must be conveyed to the other party, because if there is any problem later, okay, whatever losses can be claimed from the contract breaker. Otherwise, no claim is allowed. Because why? It is considered as the damage is too remote. So illustration P and Q, okay, this is the analysis actually from the illustration. You can read on your own later. We have we read Q? Not yet. Okay. I read to you P just now, but you can read Q on your own. So in both of the illustrations, okay, contract breaker A did not know the purpose for which B bought the cotton and cloth. Okay, for illustration Q, it involved cloth. Okay, for illustration P, it involved cotton. Therefore, A is not liable to pay damages to B for the closing of the mill. So the cost of preparation for manufacturing caps, that one for illustration Q, okay, and the loss of profit expected from the sale of the caps, okay, unless everything is made clear to the contract breaker from the very beginning, then whatever losses later can be claimed from the contract breaker. Okay, that's the case. Okay, we're going to discuss the case before we end the part 3. Okay, all right, so this is the case on remoteness, okay, and also related to second limb. Daishowa Malaysia Wood Products Sdn Bhd and Kepung Wood Products Company Sdn Bhd 1980. This is a appeal case, judgment by federal court, so it carries higher weightage. Okay, appellants installed 2 chipping plants, okay, in the respondent's factory. So they have different role, okay, here, but they have contract between them, and agreed for a period of 5 years from January 1974 to purchase all wood chips produced by the respondent on certain terms and conditions. So respondent is responsible to produce the wood chips, and then appellant would buy, okay, whatever wood chips produced by the respondent. The agreement was renewable for another 5 years. So first it was signed for 5 years and then later renewable, okay, at the option of either party. So both have the option to renew it. But okay, they sign it in 19 in January 1974, and 4 months after, okay, May 1974, appellants requested respondent to increase production. They say, oh, I need more, so please produce more. So in compliance with this request, respondent bought certain machinery in order to increase production, okay, to meet the demand or request by the appellants. But later, okay, a year later, due to bad market conditions, appellants accepted delivery of reduced amount of wood chips, okay, and later by August 1975, a year after, okay, they refused to take any further delivery of wood chips from the respondent. No, I don't need any more wood chips. Okay, remember a year before they asked for increased amount, okay, increased production. Now they don't want to buy anything. So now, and then appellant stated that they were no longer bound by the terms of the agreement. So they say, oh, we are released from our contract. Okay, we are not liable for breach whatsoever. Okay, and respondent, because of that, respondent sued appellants for breach of contract. And now respondent claim for 2 types of damages. Okay, the first one, loss of profit from April until August 1975. And another one, estimated loss of profit from September 1975 until December 1983. Inclusive of optional renewal period of another 5 years. So they claim everything actually, actual losses, estimated losses, okay, and then the expected optional renewal period, okay, so everything they claim from the appellants. So this is observation or finding by the court or judgment here. Appellants were liable for breach of contract. Yes, there was breach, and respondents were awarded loss of profit during the initial 5-year period of contract. Yes, they can claim because they have signed the contract. But the court refused to award any sum for the renewal period because why? In the circumstances, the agreement was unlikely to be renewed. So there's no way that they will renew the contract. So cannot claim for the loss of expected profit here. So loss of profit during the renewal period could not be said to be a loss reasonably foreseeable, as likely to result from the breach. So basically, the loss is too remote, okay, during the expected renewal period, because there's no likelihood for the contract to be renewed because they don't need any more the things cheap, is it? Okay, wood chips just now. Okay, that's all for part 3 of the lecture. Okay, I'll stop share first. We are going to continue later on measure of damages in next part. Okay, thanks for listening. Assalamualaikum warahmatullahi wabarakatuh.